It's what they call rebuttal. And if I seem stilted in it, please excuse me. Normally, they get rebuttal. But because I have the burden of proof, I get the last word, which I think a lot of people would tell you I like. And I do. Anissa Weier believed that she could become a proxy of Slender Man, an internet demon that existed. In her mind, he existed. She became, over a period of about 6 months, convinced that he existed through her close relationship with poor Morgan Geyser. You saw that child, Morgan, singing in the room with Detective Casey. He seemed to think she was lying to him. I think my eyes tell me something else. Just as the recounts of her at school, playing with blood on her desk, being told to clean it up because she might be stigmatized, chasing children, barking on the playground, playing with Voldemort and Snape on the playground. The children all came and said to the teachers, "This is happening. Something's wrong." And the adults all said, "Quirky, wants attention." Anissa wanted friends. Do you think that the choice to remain with Morgan helped her in that quest? We know from her teachers that other children kind of liked her. She had a few friends in Flight Academy, and with those friends she also shared her interest in creepypasta, none of which got shared with the teachers by any of the students, because kids don't talk about those things. And people who are in a shared delusion don't share with outsiders. It's like the old Brad Pitt movie, Fight Club. It's the first rule of Fight Club. You don't talk about Fight Club. When you are in the control of an internet demon who can teleport and read your mind from wherever his eyeless face is, you don't tell people. Because what will happen? The internet, the wiki tells you what will happen. He will come. And you will die. All three doctors were asked if the fact that in her interview, Anissa said that Morgan told her about her deal with Slender Man after the offense changed their opinion. All three of them said no. This girl was under the control of a delusion that had developed between herself and Morgan. She was afraid to be crazy. She didn't want to be crazy. And she didn't want Morgan to be crazy. No one wants to be crazy. That makes sense. But a delusional system, to those who are not a part of it, doesn't make sense because it's crazy. Whether it's a pain in your toe that you believe the alien put there, the CIA monitoring your brainwaves, all of the different things you hear about over time, all of the different examples the different doctors gave of delusions. When you confront someone with a delusion with factual information that should pop the bubble of the delusion, the response is to believe that you are part of the conspiracy, or, I think in Anissa and Morgan's case, that you can't see the danger, that they have this special connection and you don't. And because of that special connection, you also create a risk for the people around you, because if you spill the beans, he will come. And they had both seen him. One of the most telling moments for me when Anissa is talking with Detective Trissani is where she says, I needed to prove he was real because I saw him. I saw him before and after the offense. This was a real being to this child. And and she needed to protect those around her. Separating herself from her family was one of the most painful things she could do. She brought pictures along, as did Morgan, of their families because they thought they would never be able to see them again. She talked about asking Morgan, couldn't we wait another day, because she didn't want to leave her family, but she felt she had to. Because that special relationship, that connection, if you spill the beans, or if Morgan went ahead with the plan and went to Slender Mansion without you, would result in harm. And I know when in the statement Anissa said that to Detective Trasani, but we have a traumatized 12-year-old talking to a detective. Again, I don't think it matters when Morgan told her, but I don't know that her timeline is entirely accurate because she's 12. But to me, it doesn't matter because, as the doctor said, the delusional belief was in the existence of Slender Man, this demon who could teleport, who could read your mind, who would know if you told because he always watched. You saw the pictures from Morgan's locker and the always watches written in the back of Anissa's Spanish notebook, not quite to the last page where someone might look and not with her homework, but in the middle where no one would find it. He's always watching. And her friend is now always watching, and they're feeding into each other. And one of the things that I think tells you just how frightened and confused she was is if you look at the exhibit I've put on Exhibit 2. Detective Casey testified about this shortly before the party, May 23rd. Anissa hadn't turned in a choir assignment. She was in trouble. And her mom wasn't going to let her go to the party. What was Morgan's response? If your mother keeps you from coming, I will crawl in the window and add her to the list of bad people. What do you think that meant to Anissa? When you think of the emails that have been sent to Payton about how they would come through the window to get her, Anissa knew her family was in danger. Anissa knew she was in danger because her very thoughts could cause this demon to come. At 12 years old, she had no way to protect herself from this except to follow Morgan's advice. And they swirled down into madness together. The state asks you to ignore the 3 doctors because they don't like what they say. And I think in part they don't like what they say because it's frightening. We don't want to believe children are sick, and we don't want to believe we miss it. You have the opportunity to fix what was missed. The evidence, all of the evidence that came in tells you that Anissa Weier was suffering from a mental disease or defect, that the combination of her mental health issues, the schizotypal, the depression, and particularly the delusional disorder combined with her young age kept her from being able to do the right thing, kept her from being able to understand that this was wrong and led to this terrible event. When you look at the verdict form, all of the evidence tells you that she suffered from a mental disease or defect. And all of the evidence tells you that she could not conform her conduct to the requirements of law. And I believe when you look at the evaluations that were done of her by Dr. Caldwell particularly, because he saw her less than 2 months after this event, when she was still that 12-year-old child, I also believe that she could not understand the wrongfulness of this. Did she know it was illegal? Yeah, sure sounds like it. But there are things that are illegal that are maybe not wrong. Or there are things that are illegal that in the moment that you are dealing with are not wrong. I believe, given everything that had overwhelmed her broken mind, this child could not see the difference between right and wrong and was compelled to participate in this. The judge has given you the opportunity to place this child under commitment and to give him the authority to place her in an appropriate institution. She's been held for long enough. Let's place her where she belongs. Thank you.
Thank you, Attorney McMahon. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You are not to be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to render a just and true verdict. If you answer yes to question 1, then answer question 2 of the verdict. Any consequence of your verdict are matters for the court alone to decide and must not affect your deliberations. In this case, the law provides that the verdict must be agreed to by 5/6 or more of the jury. Any verdict returned by the jury shall be agreed to by at least 10 of the jurors. I ask you to try and be unanimous if you can. When you retire to the jury room, select one of your members to preside over your deliberations. That person's vote is entitled to no greater weight than the vote of any other juror. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. At the foot of the verdict, you will find a place provided where the dissenting jurors, if there be any, shall sign their names. Either the blank lines or the space below them may be used for that purpose. Now, we've used numbers, I've said signatures, so for your purposes, signatures are numbers. So instead of signing your given name, you'll use the juror identification number previously assigned to you. We're going to select the alternates in a minute, but at this point I want to swear the officers who will be in charge of securing the jury.
Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or speak to them yourself, except to ask whether they agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberation or the verdict they agreed upon? So help you God.
I do. All right, thank you. Now we'll select the alternate jurors. In complex trials at length that can last a period of days, it's been my practice to always select alternate jurors. In this case, we had four additional jurors. The law says this case shall be decided by a jury of 12. So we had 4 extra people that were brought in as jurors. We don't know who the alternates are. We will in a minute. I think everybody involved in the trial, any trial, but certainly this one, respect the time that you've all spent in hearing the case. And in some respects, then, the 4 alternates are deprived of the final ability to participate. In thinking about it, it's somewhat like having a book from the library on your Kindle, and then the time expires and you're almost done, but the book evaporates because it goes back to the library. That is the unfortunate circumstance of being the alternates. What we are doing, though, just due to we're going to select the 4 alternates. We're going to have those alternates stay here at the courthouse, though, in a separate jury room in the event there's a need for an alternate sometime during the deliberations. So we'll first, we'll first identify the alternates, and then those alternates will be released. to follow the bailiff to the location that they'll be at. And then the other 12 then will be released to go to the jury room to begin the deliberations. After you arrive at the jury room, for those that are deliberating, I will provide a set of instructions as well as the official verdict, which is blue-backed. The official verdict is the same as the one you have, with the exception that it's got a blue legal folder on it. Now, as I indicated when we selected the jurors, we used this bin to select the alternates. That's how we used to select jurors. Little pieces of paper with names were put in there. They'd be twirled, and then we'd pick the paper, read the name off, and they'd come out and have a seat to begin the process. In this matter, we have 16 numbered blocks of plastic tabs, each one with a number on, 1 through 16. There's 16 jurors. We've asked the jury clerk to run an ad to list the jurors at random, 1 through 16. So it's been a new computer run, a random run. We'll have the attorneys twirl, and we'll have the attorneys, one of the attorneys do the twirling, one will do the picking, and then one doing the picking, or they can alternate. We'll pick 4 blocks out. We'll correlate those numbers with the listing on the at random list, and we'll call those names off by the clerk. The clerk will then will have those 4 be released. I do it this way not so much for the drama, although it's sometimes interesting to watch, but because I want you to know, and I want the parties to know, that this is as random a process as we can do to select the alternates. So with that being said, I'll ask one of the attorneys from each of the sides to come up, inspect. No hesitation. And verify we have 16 blocks of plastic blocks with numbers, and that the bin is empty. It looked well twirled. And you just read off the number.
Number 5.
Somebody has to pick another one. You can just pick them now. Pick them all at once.
15.
2.
There's number 2.
Correct.
All right, so we have 5, 15, 2, and 6. Thank you to the attorneys. Please seat them. Now, what I'll ask, as the numbers are called off, I'll ask you to stand, and then once standing, Ken, you'll take care of that issue. Okay, very good.
9902 4854 1881 10749.
All right, well, thank you for serving as jurors. You'll be alternates then, and we'll follow Ken, and you'll stay here during the course of the trial until the jury reaches a verdict. And then we'll be brought in at that time as well, but it'll be for the jury verdict. So, thank you, and we'll talk to you later. You are released. Okay, we have 12 jurors that are left at this point. The jury will be released then to begin the deliberations. Please stand for the jury. All right, thank you. Please be seated. From the standpoint of Ms. Weier, any objections to the manner in which the instructions were read?
No. No, Judge.
Thank you. From the state standpoint, any objection to the manner in which the instructions were read?
No.
All right, very good. Then we'll provide a set of the instructions and the verdict. All right, very good. Then we have to talk about exhibits. What I'd like, one, we have to decide if there is a request for an exhibit, which exhibits go in. If there's determined that all exhibits go in, or whatever it has to be, but we have to go through it, attorneys should consider that carefully so we can make that decision. Once we decide what are the available exhibits that should go in, then we have to decide if they ask for an exhibit, does only that exhibit go in, or do they all go in? Or do we send all of the exhibits in at the beginning? The issue over the over the CDs and the recordings, of course, those CDs will not go in. And in the event there's a request to have something played back, I'm going to on the CDs. We rely upon the CD as being that testimony. So I can give you a few minutes to review that issue if you'd like, or if you'd want to even confer among yourselves how to address the issue of which exhibits are available going in. Can I see the official exhibits? Or is it on? Oh, I'll look it up. With that being said, then, from Ms. Weier's standpoint, which exhibits, did you make a decision from your standpoint which exhibits should go in?
We did, Your Honor. We would not have any objection to any of the exhibits being sent. However, we think F1, and I believe there's an F2, which was the follow-up.
Yes.
Unless they're requesting the DVDs, it doesn't make sense for that to go back. Or even if it is, it seems it sort of has our titles on it, so maybe we keep F1 and 2 out.
So you're stating then that from your standpoint, on Ms. Weier's side, that all of your exhibits would go in, or can go in, with the exception of exhibit E, F, F1, F2.
Well, Your Honor had indicated that you did not intend to just send the DVDs back.
Correct.
So, yeah, but if they do request the DVDs of the statements, I guess we'll, as you said, address it as a request for readback.
All right. Now I have, did the defense move in, or rather, did Ms. Weier move in exhibit AC? That's a report summary of Anissa's goodbye note and will.
Yes, I believe I did.
That was moved in. We don't have that listed as being moved in.
Your Honor, it does.
That was the one on the
summary of it?
AC.
We did not use that.
All right, so AC,
We had a
although
typed
marked,
up
has not
version
been
from the
used. All right,
detective's
that's what I
report.
wanted to know.
Okay.
So that's correct. All right. Now, before, I'm going to ask from the state standpoint on your witnesses, or rather on your exhibits, any position on those?
Actually, I think the position that Ms. McMahon was the mutual position on all exhibits.
All right, so,
Correct.
okay, so all exhibits may go in with the exception of exhibit E, F, and then F1 and F2.
Yes, sir.
Yes.
All right, very good. Then, so that'll be the rule for this proceeding. Now, do we send the exhibits in without anybody asking for them? Do we wait for them to ask, and then if they ask for an exhibit, do they get just the exhibit or exhibits asked for, or when they do that, do they get everything? So let's first ask, should all exhibits go in now?
The state's normal position is that when requested, they should go back, and we've already addressed it, so you don't have to call us in chambers, but if they don't want them, that there's no reason to send them back, but
All right.
And that was our thought as well. If they ask for them, we should send, and even if they ask for just a specific exhibit, I believe we agreed that perhaps it would make sense to send all back at once.
So then the exhibits will be held here. The ones that go back will be held until they ask for exhibits. And if, correct?
Correct.
Any objection to that? And if they ask for an exhibit or exhibits, all go back.
Yes.
Yes.
All right, very good. That'll be our rules then. That's how we'll follow. Now, I urge the attorneys to look at the exhibits then that are going in, if asked for, to be sure they're in proper order and that they're properly here. I say that because I had one experience one time when I was a practicing lawyer, when we missed something, and of course something went into the jury room that shouldn't have gone in. So I just be sure attorneys are responsible to be sure that the exhibits are properly marshaled together.
Okay.
Okay.
All right. Then if we will, if we have any questions, if they ask for exhibits, we'll let you know they asked, but we're just going to send them back. If they bring other questions to the court, I won't act on them until you've had a chance to come into court and look at it. And if we have any other issues that come up, let us know where you're going to be if you're here at the courthouse, or if you're leaving, certainly be able to be back within 10 minutes of a call. So be sure we have your cell phones, or if you're staying here, your office extensions.
Will you have Ms. Weier wait at the juvenile center? Or
Well,
will you have her wait here?
I haven't thought about that. What's the transportation time?
That was our plan.
That is the plan. All right, that's what'll happen. She'll wait at the juvenile center then. And then be brought back. She has to be brought back, of course, for any
Of course, any
questions that come up,
questions or-
any type of activity in the courtroom. Ms. Weier has an absolute right to be present.
And will her family be able to go there and visit with her?
I think that may be a little complex at this time, just from the standpoint of how things could operate. So I think at this point, I'll say no. We'll just have Ms. Weier over at the juvenile center at this point. With that, then, we'll be in recess. Court will be here. Thank you. It was a good case presented by all parties. Thank you for your professional approach.
Thank you,
And
sir.
good luck.